All right, we can go off the record. Here's the thing, you're young. Let me just tell you something. If you want things, go out, get a job so you can afford things. But at the end of the day, when all of us die, guess what? Your things cannot go with you. All right, why are you riding in stolen vehicles?
I ain't gonna run the wrong crowd, to be honest.
No, you are the wrong crowd. That's what other people would say. Court is calling 2024 CR 2985, State of Texas versus Daniel Balderas. Can I have parties that for the record for the state? Defense?
Elizabeth Settle for the defense.
Are you Daniel Balderas?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Balderas, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Balderas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. This is the one concur with County Court Cause number 733375. There's to be restitution, if any, to Maybelline Cortez. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Conscious, ma'am.
State, any evidence?
State offer state exhibit 1 and all evidence.
No objection.
All right, and state, have you spoken with the complainants?
Judge, we've made attempts to reach the complainants, but so far I don't think.
All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation and testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea bargain.
All right, how old are you?
19, ma'am.
All right, why are you riding in stolen vehicles?
Just hanging around the wrong crowd, to be honest,
No,
ma'am.
you are the wrong crowd. That's what other people would say. The co-defendant or the other suspect who's with you, Sandoval, his family would tell me he's hanging around with the wrong crowd, and that would be you. So what are you doing with your life?
To be honest, I'm just trying to finish school and get a job and just do good.
How are you just trying to finish school? What are you doing?
Well, right now I'm looking for like schools to be able to get my GED and my high school diploma.
You can find that anywhere on the computer. If you can drive around in a car that doesn't belong to you, I'm sure you can go on the computer. Do you have a phone?
Yes, ma'am.
A cell phone?
Yes, ma'am.
I'm sure there's Google or whatever on that cell phone. You can Google, there's places throughout San Antonio where you can get your GED. Why didn't you finish school?
And I was in juvenile, didn't get a chance to finish it.
All right, do you have any children?
No, ma'am.
Okay, that's a good thing. You need to get your life in order. You understand?
Yes,
Who do you
ma'am.
live with?
My mom.
All right. This is what the court will do. There is a $500 fine. That will be probated. Court is going to sentence you to 2 years deferred adjudication. This is run concurrent with County Court Cause number 733375. There's to be 120 hours of community service restitution. That will be waived if you obtain your GED or if you're in some sort of trade school and you graduate. Do you understand?
Yes, ma'am. I did.
There's to be regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Clean.
All right, when's the last time you used?
Months. Since like six months.
And using what?
Marijuana.
All right, there's going to be regular random UAs. And make sure he's tested for levels if he comes out positive. If he is positive, what we're going to do is there's going to be the UA hotline if he's positive. And he's going to stay on that UA hotline until he presents with a negative UA. And then we'll go back to regular random UAs. There's going to be proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There is to be no contact with the following persons. Kevin, I don't know if this Kevin, in the police report it's Keving. Ricardo, Richardo, Alvarez Sandoval. There's to be restitution and no contact with Maybelline, Mabeline, Ashley Cortez. And let him take the theft course. And there's to be field visits 1 time per month until he is employed or obtaining his GED. Probation, is there anything else he needs?
No.
Is there anything else you need from the court to be successful?
I was just wondering about my GPS monitor. The hours, it's been kind of like interfering with me getting a job because I already had like 2 job interviews, but the hours that I got for my curfew, like my officer said he wasn't able to do nothing about it. So
All right, we'll extend his curfew on GPS. So his curfew, he's allowed out of the house from 7 a.m. to 8 p.m. Monday through Fridays. And then Saturday and Sunday, he's to be at home unless he's employed or at school.
Judge, how long will he be keeping the monitor on?
Until further notice. We'll see how things go. How long you are on that monitor is 100% dependent upon you. Do you understand?
yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing, you're young. Let me just tell you something. If you want things, go out, get a job so you can afford things. But at the end of the day, when all of us die, guess what? Your things cannot go with you. Although I've heard of people being buried with their car, which I don't know why you would do that, because it costs extra, I'm assuming, to have a car for you to be buried in. But I'm sure if you're driving around in vehicles that don't belong to you, you're not necessarily attached to it. We should not be attached to things anyway. You understand? All right, good luck to you. You're welcome. Court is calling night mag number 753623, 753624, State of Texas versus Ray De La Rosa. That parties announced for the record for the state.
Zach Dunn for the state, Your Honor.
Attorney John Garcia for response for defendant, Your Honor.
All right, and are you Ray De La Rosa?
Yes, ma'am.
All right, the court is in receipt of a third motion to modify terms of bond release. State, have you had a chance to review the defense's motion?
Yes, and defense and I spoke, Your Honor.
All right, and state, are you ready to proceed?
Yes, state's ready, Your Honor.
All right. State, are you in agreement with the motion?
No, Your Honor.
All right, defense, do you have any witnesses?
Yes, we do, Your Honor. We have Mr. De La Rosa's wife.
All right, Mr. De La Rosa, if you move over to the side.
Judge, how many do you want on the panel for now?
75.
She's a-
All right, if you'll come forward. You need to put your items down. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, lower your hand. You're going to need to keep your voice up so that the court reporter can hear and so that I can hear.
Okay.
If you do not speak up, then your testimony is for naught because I cannot hear you. Do you understand?
Yes.
All right, state your name for the record.
Herlinda Corta.
All right, and spell your name, please.
HERLINDA ALCORTA.
All right, everyone, we're on the record. You need to whisper. Defense, your witness.
Yes, okay. You're the complainant in the two cases against your husband that we're asking for a bond modification for no to be changed from no contact to no harmful or injurious contact, correct?
Yes.
Okay, and you feel that affidavit's a non-prosecution in both those cases?
Yes, sir.
Okay, and you have no problem with that motion being approved by the judge, correct?
No, sir.
I'll pass the witness, Your Honor.
Just one clarification question. Ma'am, you came by the 5th floor of the Cadena Reef Center to drop off the aforementioned affidavit of non-prosecution, correct?
Yes, sir.
And you told the person at the front window that you were with your brother, correct?
Yes, sir.
Okay, but does your brother have a similar Jesus tattoo on his left arm?
No, my brothers have tattoos.
Does he have a Jesus tattoo on his left arm?
My brothers have two, but they have Jesus on. They have bottom and top.
So my final question is, did you show up with the defendant or did you show up with your brother?
That was my brother. I have not seen Mr. Ray De La Rosa since last year.
No further questions.
All right, any other questions?
No, Your Honor.
All right, thank you.
Yes.
Defense, Mr. Rosa, you can say it. Any other witnesses?
Nothing from the state now.
Nothing from defendant, Your Honor.
All right. State, you're opposed?
I apologize, Your Honor.
You're opposed?
Yes, Your Honor, we are opposed.
All right, for what reason?
We have good reason to believe that they actually showed up together to drop off the MP, which is of course a violation of the no contact order. And I think the state's position is clear only in that when you're awaiting 5 indictments and 6 cases total, we believe that just in the best interest of community safety, to not lift this, Your Honor, so that is why the state's.
All right, defense?
Your Honor, my client has been following the bond conditions. He hasn't had any problems for the last 5.5 months. His wife has filed 2 affidavits of non-prosecution. She has no problem with the modification being changed from no contact to no harmful or injurious contact. My client is an older person and his spouse is an older person. They would like to be together.
How old is your client?
60.
Okay, that's not old.
I don't feel it's old. Now that you say it, I don't feel it's old. But we're asking if you could please allow for that bond modification, Your Honor.
All right, so here's my question. He has 2 cases before the court. NITMAC number 753623. What is the charge in that case?
So, fortunately, the system only pulls up the grand jury numbers. You're also gonna have to click into each one. I apologize.
No problem.
There's a myriad of assault seconds, so I'm gonna.
Well,
This
is what I want clarification on. The 2 cases that he's before the court now, asking that he be allowed contact with his spouse, are those assault family second cases?
Is one, go ahead. Go ahead, counsel.
Go ahead.
Is one of them 753623?
Yes.
That's an assault second.
And the other is 753624.
753624, Your Honor, is a violation of protective order assault stop.
All right. So now this is my next question. In each of those cases, who is the complainant? I'm assuming the complainant and the cause number ending in 23 is his wife?
Yes, Your Honor.
And who is the complainant and the cause number ending in 24?
Linda as well.
His wife?
His wife is his spouse as well, Your Honor.
All right. So your motion is denied. Is there anything else?
Yeah. Does the district attorney have a time frame about when the cases will be invited, or?
Oh, you'll have to speak to them about that. All right, your motion is denied. Is there anything else?
Nothing present from the court, Your Honor.
All right. We can go off the record. So, Mr. De La Rosa, you have 2 cases. In both of the cases, your wife is the complainant.
She's not the one that complained. It was her sister.
Mhm.
Her sister's the one that complained. She's the one that called out a person. I want to be in the prison.
Well, maybe your sister, well, here's the thing. Maybe your sister-in-law will come down and testify.
I hope she does.
Yes. All right. Thank you.
Thank you, Your Honor.
You're welcome. All right. The court is calling 2024 CR 1908, State of Texas versus Miriam Patron Martinez. Can I have parties announced for the record for the state,
Andrew Harrison.
for the defense?
Call Alexander Patron.
And are you Ms. Patron Martinez? Yes, ma'am. All right. We were here and the defendant entered a plea to the lesser included offense of obstruction of a highway as a Class B misdemeanor. The defendant entered a plea of guilty. The court found the defendant guilty. And according to the plea bargain agreement, punishment was to be assessed at 60 days in the Bexar County Jail with 1 year of driver's license suspension. Both parties agreed that she could consider doing full house arrest as opposed to going to the Bexar County Jail. The reason being is that there are issues at the Bexar County Jail, health issues, and also because there was no one to take care of personal things she needed taken care of at home. Is that correct?
Yes, ma'am.
And neither party had an objection to that. And I believe you had to confer with your client concerning that.
Yes, ma'am. We had to make sure she had the finances in order because of what the cost is associated with the monitor, as well as make sure that she understood the parameters of that. She was okay with it. She's elected to go along with that.
All right.
Carl Alexander.
All right. Then, as previously stated, on June 3rd, the court is finding you guilty the Class B misdemeanor of obstruction of a highway in lieu of 60 days in the Bear County Jail. The court will sentence you without objection to 60 days full house arrest. And there's to be a 1-year driver's license suspension. You are aware that with full house arrest GPS, what that means is that you're not allowed to leave your home for any errands or anything of that nature. You understand?
Yes, ma'am.
And you do understand with a 60 days house arrest on GPS, that's probably a longer sentence than you would have had to serve at the Bear County Jail.
Yes, ma'am.
All right. So that'll be full house arrest on GPS. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes, ma'am.
All right. And counsel, if you remain in court, we're going to have to see with the Bear County Jail the placement of the GPS.
Yes.
And she may need to actually physically go to the Bear County Jail. And when I say physically go there, on Kamal Street, and they will fit you there with GPS. So just remain in the courtroom and we'll see what's the best way to accomplish that goal.
Yes, ma'am.
All right. Is there anything else from either side?
There you are.
All right. Thank you. Just remain in the courtroom. Thank you. You may be excused.
What?
Right. It's not needed. She'll be released today. Yes, no, she's not going to the Bear County Jail.
She's gonna go, we're gonna take her.
No, she's gonna go herself. Yes.
Oh, she won that.
You gonna take her?
All right, it's gonna take.
But what we're gonna do is, counsel, you're gonna call over to the Bear County Jail now.
Oh, okay.
Deputy Laura, they may have the number, and we're gonna see specifically when she needs to report to have the GPS placed on. If that is not done, a warrant's gonna be issued for you, and you're gonna be serving your time at the Bear County Jail. Do you understand?
Yes.
All right, so, just have a seat on the front row on this side, and we'll see about that.
Mayor, I just wanted to give you an update about the
Yes.
the GPS search. So I spoke with Corporal Gonzalez, thanks to Deputy Laura, she knew the numbers. So until the sentence and everything is updated in Odyssey, so they then have a mandate, she can't go over. But as soon as that's done, she's just to report to the South Tower and let them know that she's there to get her GPS unit.
All right, so that should be updated in the system today. So I'm gonna order, well, we know what's happening with Odyssey. On this case, I'm gonna order that she's to report to the Bear County Jail no later than, let me see.
No, we're going to judge. I'll have it entered as soon as possible.
Oh, no. What I'm gonna do is she's to report to the Bear County Jail for the GPS no later than Wednesday, June 26th.
Okay, so gives 2 days for everything to catch up. And is that when she'll start serving her sentence, or?
Once it's placed on. All right. On that one, she's going to report to the jail on June 26th. Yes. Nick Gomez, yes.
May my client and I be excused, sir?
Yes.
Thank you. Good
All
night.
right. Just make sure she knows where to go.
Yes, ma'am.
Okay. Court is calling 2024 CR 2158, State of Texas versus Maria Cisneros. Could I have parties announced for the record for the state?
After her said,
Defense?
Doug Campbell.
And are you Miss Cisneros?
Yes, ma'am.
Cisneros? Counsel, have you received all the discovery?
Yes, Judge.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Ms. Cisneros, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
yes, sir.
Thank you. My understanding there are two cases for
Yes, Judge.
Cisneros. And Ms. Ferguson, on this, we're going to need a a date for sentencing?
I can do audit date.
Okay.
Okay.
All right, and the court is also calling 2024 CR 2004. Again, counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
And Ms. Cisneros, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am.
Did you review the true bill of indictment? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions? And the cause number ending in 5-8, you're charged with aggravated assault of a security officer. The range of punishment is 5 to 99 years or life in prison and up to a $10,000 fine. And the cause number ending in 0-4, you're charged with retaliation. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering a plea in each of these cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea agreements in each of these cause numbers?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication in the cause number ending in 5-8, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication in the cause number ending in 0-4, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Did you understand?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Judge.
In each of the cause numbers, do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
In each of the cause numbers, do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Cisneros, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. And each of the cause numbers, did you review the plea bargain agreement with the state
Yes, ma'am.
and with your attorney?
Yes.
Did you understand, according to the plea punishment is to be assessed at 8 years in the prison? There's a $1,500 fine. The state is silent on your applications. The causes are to run concurrently. And if the court finds that a weapon was used and the cause number ended in 5-8, then the court could enter an affirmative finding of deadly weapon. Do you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
And each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions? Outside the agreement, the state is asking for no contact with David Munoz and Alejandra Aguirre. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in the cause number ending 0-4, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And the cause number ending in 2158, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea.
Case containing within Exhibit 1 and attachments, Your Honor.
No objection.
All right, state, you may be excused.
Thank you.
You're welcome. And each cause number, did you review the documents entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
All right. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. And this will be called back on August 5th for sentencing. I'm going to order a PSI. Is there any other mental health or anything of that nature?
Judge, my client is taking, I forget what she told me, but it's a mood stabilizer. And I think, Zyprexa? Thank you. She takes Zyprexa as a mood stabilizer. I'm fairly certain that she told me before we came to court that she's got depression and bipolar, but I have a feeling with the mood stabilizer, it's something more serious. So there's that.
All right. So probation, that's going to be a PSI, a TAP evaluation, and a MIC evaluation. All right. Thank you.
Thank you, Judge.
Oh, they tell me it's August 8th.
August. You know, that's what I wrote down when I heard it.
All right. August 8th. All right. Thank you.
And that's where this courtroom session leaves us. 3 very different cases, 3 very different decisions, and one common message: a second chance only matters if you actually use it. What do you think about the judge's decisions today? Let us know in the comments.